So, good day everyone. My topic is all about compensation. So, in Article 1278, it says that compensation shall take place when two persons in their own right are creditors and debtors of each other. So, but first, let's find out what is compensation. So, compensation is the extinguishment to the concurrent amount of the debts of two persons who in their own right are reciprocally principal debtors and creditors of each other. When you say concurrent amount, it means that is one debt is bigger than another one. So the balance shall subsist, meaning compensation could be complete or it could also be partial, and these two debts are extinguished without actual transfer of money between the parties that takes place by operation of law. So let's proceed in compensation distinguished from confusion. So in compensation, there must be two persons who, in their own right, there are the creditors and debtors of each other. And the second one is in compensation, there must be at least two obligations. So while in confusion, there is only one person in whom is merged the qualities of creditor and debtor. In confusion, there's only one obligation. So in short, in compensation, there is two persons who in the right, which is the creditors and the debtors. And the second one, in compensation, there must be at least two obligations. While in the confusion, there is only one person. And the second one is there is only one obligation. So this is the Article 1278. So I will repeat it again. Compensation shall take place when two persons in their own right are creditors and debtors of each other. So, let's proceed in kinds of compensation. There is two kinds of compensation, which is as to cost and as to effect. Now, let's proceed to the number one, which is as to cost. Under the as to cost, there is letter A, which is legal. It says here that when it takes effect by operation of law from the moment all the requisites prescribed by law are present. Legal compensation takes place ex jure when all the requisites of law are present. So in legal, it says here that it takes place by operation of law. So it means that all the requirements of law is present. So let's proceed in the letter B, which is the voluntary or conventional. So in voluntary or conventional, it says here that when it takes place by agreement of the parties. And also conventional or voluntary compensation, which occurs when the parties agree to the mutual extinguishment of their credits or to compensate their mutual obligations even in the absence of some of the legal requisites. So, voluntary or conventional says that when it takes place by agreement of the parties. And the number three is the judicial. So, judicial is when it takes effect by the judicial. So, when it takes place by order from a court. And then letter D is facultative. When the compensation can be set up only by one of the parties. So it says that when it can be set up only by one of the parties. Usually, if facultative, not all requisites of illegal compensation are present. It is allowed into one party to compensate or not. Now, let's proceed in the number 2, which is the as to effect. There are two um, there is two in under of as to effect. The number 1 is total. When we say total, when the two debts are of the same amount. When both obligation are the same amount, all the same amount, and are so the same amounts entirely extinguished. So the number 2 is partial, which is when the debts are not of the same. Now, let's proceed in the Article 1279. So, it says in Article 1279, in order the compensation may be proper, it is necessary. Number 1. The each of one of the obligors be bound principally, and that he be at the same time a principal creditor or the other. And the number 2, the both debt consists in a sum of money, or if the things due are consumable, they be of the same kind, but also of the same quality if the latter has been stated. So in number 2, their obligation is both consumable things, but not the same kind of quality. So the number 3. The number 3, the two debts be due. Debts should be due. Both debts should due at the same time has been fulfilled. So and the number 3 is number 4 is that they be liquidated and demandable. But first, what is demandable? When we say demandable, it is in the sense or to the fact that no obligations are illegal or invalid. So both are valid and at the same time, it's demandable. And when we say liquidated, the two debts are liquidated, meaning the amount is known or can already be determined by simple computation. The number 5 is that over neither of them there be any communicated in due time to the debtor. So, no retention or uh, controversies has been commenced by a third person. So, this is the negative requisites for the legal compensation. So now let's proceed in the Article 1280. It says here that notwithstanding the provision of the preceding article, the guarantor may be set up compensation as regards what the creditor may owe the principal debtor. So, this article obviously talks about the compensation benefits the guarantor. Although the guarantor is only subsidiary, he is not principally bound. He is given the right to set up compensation. So the next one is Article 1281. So it says here, compensation may be total or partial. When the two debts are of the same amount, there is a total compensation. Meaning, total compensation result is the two debts are of the same amount. So the compensate each other, totally extinguishing obligation. But if they are not the same amount, compensation is total in the smaller amount debts and partial only in the larger debts. Now, let's proceed in Article 12A2. Article 12A2, it says here that the parties may agree upon the compensation of debts which are not yet due. So, in this article, this is now voluntary compensation. It is an exception to the general rule that only debts which are due and demand able can be compensated. This kind of compensation has no special requisites due to it is sufficient agreement or contract of the two parties, which the two contract declare that the two compensation should be valid. Now, let's proceed in Article 12.8.3. In Article 12.8.3, it says here that if one of the parties to a suit over an obligation has a claim for damages against the other, the former may be set it off by proving his right to said damages and the amount thereof. So, this article refers to a judicial compensation or set-off. Compensation may also take place when declared by a final judgment of a court. A party may set off his claim for damages against his obligation to the other party by proving his right to the said damages and the amount thereof in this article. All the requisites in 1279 should also be present, except in the article at the time of pleading, the claim is not yet liquidated. Now, let's proceed in Article 12.8.4. In Article 12.8.4, it says here that when one or both debts are rescissible or voidable, they may be compensated against each other before they are judicially rescinded or avoided. So it meaning recessible or voidable debts, the same with recessible or avoidable contracts. They are valid until annulled. They valid until rescinded or voided. Hence, they are valid until voided compensation is allowed. The next one is Article 12.8.5. It says here that the debtor who has consented to the assignment of rights made by a creditor in favor of a third person cannot set up against the assignee the compensation which would pertain to him against the assignor, unless the assignor was notified by the debtors at the same time he gave his consent that he reserved his right to the compensation. In Article 12.8.5, the debtor who has to the assignment of rights may be a creditor in favor of third person cannot set up against the assignee in compensation which would pertain to him against the assignor unless the assignor was notified by the debtors at the time he gave his consent at he reserve his right to the compensation. So may kadugsong pa po yun, which is if the creditor communicated the cession to him but the debtor did not consent thereto, the latter may set up the compensation of debts previous to the cession, but not of subsequent ones. If the assignment is made without the knowledge of the debtor, he may set up the compensation of all credits prior to the same and also latter ones until he had knowledge of the assignment. So, meaning, this provision talks about the effect of assignment on compensation of debts. Under the law, if all requisites for legal compensation are present, compensation takes effect by operation of law. And so both debts are extinguished to the concurrent amount. Hence, compensation actually takes place automatically. So, this provision actually covers three cases. First, and the first paragraph is the assignment may be made with the consent of the debtor. And in the second paragraph, assignment was made with the knowledge but without consent or against the will of the debtors. So they are different in the first paragraph. In the third paragraph, it says here, the assignment may be made without the knowledge of the debtors. In the number one, it made with the concept of the debtors. But in the second one, with the knowledge of debtors, but without the consent or against the will of the debtor. And the third one, the assignment may be made or but without the knowledge of the debtor. So now, let's proceed to the effects of assignment of rights. And the number one, if the debtor consented to the assignment of rights made by a creditor in favor of a third person, he cannot set up against the assignee the compensation which pertains to him against the assignor. So meaning, compensation cannot be set up because there is a consent and so therefore a waiver of compensation cannot be set up. So, the number two, if the debtor consented to the assignment of rights made by a creditor in favor of third person, he served his right to the compensation, then he can set up against the assignee the compensation which pertain to him against the assignor. Here is the exception to the exception. If the right, there is consent in the assignment, but debtor made the reservation for his right in case of compensation. Now, let's proceed in Article 1286. In Article 1286, it says here that compensation takes place by operation of law, even though the debts may be payable at different places, but there shall be an indemnity for expenses of exchange of or transportation to the place of payment. So, in these articles applies to legal compensation. Actually, the indemnity for expenses of transportation, it applies a transportation of good. When we say indemnity for expenses of exchange, this is the expenses for monetary exchange. Like if the debts are money. So let's proceed in the article 1287. In Article 1287, compensation shall not be proper when one of the debts arises from a depositum or from the obligation of the depositary or a bailey and commodatum. So, this article 1287, this provision talks about the instances or situation when legal compensation cannot take place. In the first paragraph, so it says one debt arises from a depositum is for safely keeping it and returning the same. So when we say commodatum, it is a gratuitous contract whereby one of the parties delivers to another something not consumable so that the latter may use the same for a certain time and return it. So, yung may kadugsong pa po ito, which is, neither can compensation be set up against a creditor who has a claim for support due by gratuitous title without prejudice to the provision of paragraph 2 of Article 301. Now, let's proceed in Article 1288. So, wala po siya sa PowerPoint. In Article 1288, it says here, neither shall there be compensation if one of the debts consists in civil liability arising from a penal offense. So, meaning, if one of the debts is consist in civil liability arising from a penal offense, he will not compensate. While in legal compensation, in this situation, there is no compensation. If one debt arises from a crime, that's a civil liability arising from a penal offense. Now, let's proceed in Article 1289. In Article 1289, it says here, if a person should have against him several debts which are susceptible of compensation, the rules on the application of payment shall apply to the order of the compensation. So, in this article gives cross reference to application of payment. So, the rules of applications of payments applicable to compensation. If the debtor has a lot of debts, all of that can have a legal compensation. Now, let's proceed in Article 1290. In Article 1290, it says here, when all requisites mentioned in Article 1279 are present, compensation takes effect by operation of law. The extinguishes both debts to the concurrent amount, even though the creditors and debtors are not aware of the compensation. So, in this article, legal compensation takes place by operation of law. Compensation occurs automatically by major operation of law from the moment that all the requisites mentioned in Article 1279, if they are all present, so legal compensation takes place, even there is no agreement between the two parties, even it's against their will. So, that's all, and thank you.